So hello, ladies and gentlemen, and welcome to the final of the Undergraduate and GDL National Speed Mooting Competition 2022. We have an exciting moot in store for you today. We have the winner of Heat A against the winner of Heat B in a super final, so it should be a fun moot for you to watch. So the competitors for today's moot are Cason Yong, who is representing the appellant, and Matthew Johnson, who is representing the respondent. Now, we're running slightly different rules to normal, because normally with the term speed mooting, it's normally quite quick. So we normally have sort of 7 minutes of submissions. And to make this a more interesting moot, both mooters have 15 minutes to make their submissions tonight. So we have an esteemed panel of judges for you. So we have 3 barristers that will be judging the competition. They are Matt Mawdsley, Rebecca Keeves, and Michael Trevelyan. Once you've heard the submissions from both mooters tonight, and whilst the judges are deliberating, there will be a Q&A session. So we have a panel or 3 panelists for you, all of whom who have previously been competitors in the National Speed Mooting Competition. So we have Jazz Daliwal, who is a barrister at Citadel Chambers, Beth, Caunce, who is a pupil at 9 St John Street Chambers, and Robert Allen, who is a future pupil at Parkland Plowden. So they will be answering questions on advocacy. Now, some of you have submitted questions in advance for the session. If you can think of any questions during the night, feel free to pop them into the chat box. Or if you prefer, and you feel brave later on, you can put your hand up and ask them in person. You'll notice I'm dressed slightly informally tonight. For those of you, if you're watching in the future on YouTube, it's the 18th of July, it's 7:30, and it's still 35 degrees here in Liverpool. It's very warm. So that's why I look slightly more informal than I normally would. So I think without further ado, we will begin the mooting. So judges and mooters, are you ready?
Yep.
Okay, all right. So I will turn to the appellant first. Mr. Yong, are you ready to make your submissions?
Yes. Can I please check whether I'm audible?
Yes, we can hear you clearly.
Perfect. Thank you.
Okay, in your own time.
May it please the court, my name is Cason Yong and I appear as counsel for the appellant, Mr. Sam Andrews. My learned friend, Mr. Matthew Johnson, on the other hand, appears as counsel for the respondent, the Crown. Before proceeding ahead, may I please ask whether my lords and my lady would wish me to briefly set out the facts of the case?
No, we're fine, thank you.
Yeah, we're fine, thank you. Yeah.
I'm grateful. It is the appellant's submission that the learned first instance judge has erred in failing to exclude Mr. Marius Whitehall's identification evidence of the appellant under Section 78 of the Police and Criminal Evidence Act 1984. This renders his conviction for criminal damage unsafe. The appellant submits 2 grounds in support of the exclusion. The first ground concerns the alleged breach of Code of Practice D. As made clear in the 1990 case of Crown and Walsh, reported in the 91st volume of the Criminal Appeals Report at page 161, and
Mr. Young, for future reference, you can dispense with citations, just the case reference, just the case name, thank you.
Much obliged. The appellant recognized that not all breaches of the codes of practice automatically attract exclusion of evidence. However, if I may direct my lords and my lady to page 21 of the bundle.
Thank you.
Looking at the 3rd paragraph from the bottom.
Yes.
If I may check. The sentence reads, to our minds, it follows that if there are significant and substantial breaches of Section 58 or the provisions of the code, which in this case refers to Code of Practice D, then prima facie, at least the standards of fairness set by Parliament have not been met, and to admit the evidence would have adverse effects on the fairness of the proceedings. And it is on this ground that the appellant submit the police's failure to comply with paragraph 3.1 of Code of Practice D constituted a significant and substantial breach.
Can I just stop you there, Mr. Young? Sorry. Is it not the case, whilst myself and my fellow judges may find that there has been a breach of pace here, isn't it incredibly minor and inconsequential? The case law makes it quite clear that the important factor is the impact of any such breach on the fairness of the proceedings. Didn't the learned trial judge give a proper direction to the jury? So in the sense of anything being unfair has been remedied by the learned judge's direction to the jury.
Yes, my lord, thank you for your question. First of all, the case law that has been referred to by the first instance judge was cases involving Code of Practice C, which has a fundamentally different policy underpinning than that of Code of Practice D. As made clear in the case of Phillips and Phillips, which my lords and my lady can be found in page 56 of the bundle.
Yeah.
Let me check. My lords and my lady are with me. Looking at paragraphs 28 and 29, Phillips and Phillips made clear that paragraph 3.1, alongside other provisions in Code D, was introduced to safeguard against weaknesses of identification evidence, such as honest but mistaken witnesses, which may be potentially the situation in this case. Therefore, stricter compliance of Code of Practice D must be called for in order to remedy this potential problem that Code of Practice D was introduced in the first place. Thus, the cases referred to by the first instance judge must be distinguished. And a jury caution in this case would be insufficient. This is tied in with my second ground of submission.
Well, Mr. Yong, if I can just pause you there for one moment. You referred us to Phillips and Phillips, but isn't the judge's decision in this case at first instance entirely on all fours with Phillips and Phillips, and therefore it goes against you in this matter?
Well, my lords and my lady, if I may turn to my second ground of submission first in order to answer this question of yours. The court ought not to take authority such as McCullough and Phillips as a blanket rule for all similar future cases, because as reminded in Turnbull itself, and this can be found on page 41 of the bundle, my lords and my lady.
Yeah.
Looking at the fourth paragraph from the bottom and the fourth line from the bottom of that specific paragraph, the sentence starts with case law of this kind. If I may check, my lords and my lady are with me. It says, case law of this kind is likely to be a fetter on the administration of justice when so much depends upon the quality of the evidence in each case. Although the appellant appreciate that Phillips and Phillips decided contrary to the outcome, which what the appellant would want to invite this honorable court to reach today, those authorities should not be seen as a blanket rule preventing preventing contrary outcomes to be reached. It is important for this honorable court to scrutinize the quality of Mr. Whitehall's identification evidence closely in order to determine whether it should be excluded or not.
And Mr. Yong, just help me with that then on this point of the quality of evidence.
Yes.
Because doesn't an assessment of the quality of evidence, if that's the exercise that has to be carried out, isn't that better carried out by the jury than on an analysis of whether or not the evidence should be admissible at all?
Whilst Your Honour, sorry, I apologize. Whilst my lord, whilst that is true, the jury would be the best arbiter in determining what would be of a good quality evidence. However, it must be borne in mind that in this case, Mr. Whitehall's evidence is the sole evidence securing the appellant's conviction. This is very different from the other cases such as Crown and Walsh, where multiple pieces of evidence were put forward to the jury in order to make an appropriate assessment. The fact that there are no other evidence, as made clear in Turnbull itself at page 40 to 41, my lords and my lady, looking at the final paragraph at page 40 of the bundle. As you can see, if there are no other evidence pointing to support the correctness of the identification, the fact that Mr. Whitehall's identification evidence is the sole evidence securing the appellant's conviction, this would be an important factor to exclude the fairness or quality assessment to the jury. And it is appropriate for the judge to make an arbiter or make a decision on his or her account.
Just on that point, Mr. Yong, the defendant here, or the appellant here, has a very striking physique and appearance. Doesn't that make mistaken identification incredibly unlikely on the facts of this particular case?
My lord, that is indeed true. However, unique appearances should not be seen as a decisive factor when it comes to whether or not identification would be mistaken. It should only be one of the potential factors taken into account in the factual matrix of the case. Even if that is the case, the appellant would submit that that unique appearance would serve as a double-edged sword. Whilst having a unique appearance would allow misidentification to be unlikely in some cases, it would, in other cases, potentially increase the likelihood of confusion or misidentification because the potential witness would have unduly fixate on that distinct outlook and disregard the potential attributes, differing attributes of this potential suspect and the appellant. And this would lead to potential problems of misidentification as well. Therefore, the appellant would submit that the unique appearance on its own, whilst a relevant factor, should not be decisive, especially taking into account that it is only the sole evidence securing the appellant's conviction. Furthermore, my lords and my lady, Mr. Whitehall's identification evidence on the case is of poor quality. This is because no first description was taken from Mr. Whitehall at or around the incident to ensure non-contamination of the subsequent social media trawl. The suspect was fleeing from the crime scene at the time when Mr. Whitehall, the security guard, was trying to apprehend him, so he could only benefit from a fleeting glance of the suspect at that time. Moreover, several similar violent events occurred at other art galleries across the country. Since this honorable court knows that Mr. Whitehall himself has gone through so many social media posts on the facts of the case, on Instagram alone, one of these hashtags, #SmashTheScum, recorded upwards of 30,000 posts. The overwhelming amount of posts suggests that there's a high likelihood that Mr. Whitehall may have confused the defendant with another person. With all these potential accompanying poor quality suggestions, the fact that the appellant has a unique outlook would not outweigh the poor quality of the identification evidence. Moreover, this is accompanied by the fact that the police failed to take any first description at all from Mr. Whitehall at or around the time of the incident, which the appellant has submitted to be a significant and substantial breach. The police took no further active steps rather, to reach out to Mr. Whitehall to take description within a reasonable time after the incident. This demonstrates their flagrant disregard of the appellant's rights laid down in Code D. Instead, they waited passively for nearly 2 months for Mr. Whitehall to approach them. And it is the appellant's submission that the police's non-compliance of Code D due to mere resourcing issues is inadequate to balance against the risk of prejudice that may be brought about in the defendant's case.
Mr. Yong, you mentioned there a flagrant disregard by the police for the code, and I suppose we may or may not have to consider that in due course, but to what extent do you say that we should, or the trial judge should have exercised a discretion to exclude evidence in order to effectively discipline the police as opposed to promote the fairness of the trial? Should we, or should trial judges have a sort of supervisory jurisdiction over the way in which the police conduct their business?
My lord, it is not the appellant's submission that the trial judge or any judge in general should discipline the police or should exclude the evidence in order to essentially discipline the police. However, it is important that police misconduct or police incompetence would be a relevant factor when it comes to taking into account all the circumstances of the case as to whether or not it should be excluded. Even if the appellant concedes that the police has resourcing issues at the time of the crime scene, at the time of the crime incident, that may not permit them to take any description, they should have taken more of an active role in order to secure that identification evidence subsequently in order to ensure that fairness of the proceedings is secured. Therefore, all in all, it boils down to procedural justice. It all boils down to ensuring that the defendant or the appellant in this case was given a right to fair trial. It is not to discipline the police even if the potential indirect effect would be police disciplining, but that should not be at the forefront of the trial judge's mind. And following from there, my lords and my lady, the appellant would further submit that the cases relied on by the trial judge at first instance should be distinguished. The facts in McCullough and Phillips are substantially different from the present case. In McCullough, for example, unlike the present case, the identifying witness gave a description of the suspect shortly after the attack before going onto the Facebook site to look for the accused. Here, clearly, description was only given nearly 2 months after the incident and after Mr. Whitehall's social media troll. Therefore, there's a high likelihood of potential misidentification here.
2 minutes remaining.
Furthermore, in Phillips, the fact that there were 3 witnesses identifying the accused and the suspect in different manners, in different ways, that provides sufficient material for the jury there to make critical judgment of the fact on whether the identification evidence should be excluded or not. Here, the jury only have Mr. Whitehall's identification evidence alone and nothing else, and this would impact on the adverse effect of the fairness of the proceedings. Finally, unlike in Phillips, where only a photograph from social media was used to identify the accused, the risk of contamination here is further heightened by the fact that videos were used to identify the accused. Using the analogy quoted in Phillips, much like identifying a person in the dock as someone who committed the offense in court, Mr. Whitehall may be influenced to believe that the person in the video is the appellant who committed the offense when he's in fact not the person in question. And therefore, it is on these 2 grounds that the appellant respectfully requests this honorable court to exclude the identification evidence of Mr. Varys Whitehall under Section 78 of PACE 1984. Unless I can be of further assistance to this court, my submissions are complete.
Thank you very much indeed, Mr. Yong. Thank you.
I'm grateful.
Mr. Johnson, are you ready to present your submissions on behalf of the respondent?
I am.
When you're ready.
May it please the court, I have 2 submissions that will demonstrate that the trial judge was right to admit the evidence of the witness, Mr. Whitehall. Does the court have sight of my skeleton argument, which can be found on page 13 of the bundle?
We do, thank you, Mr. Johnson.
I'm grateful. My 2 submissions broadly follow the 2 grounds of appeal, which are before the court today. The first is that the breach of Code D was neither significant nor substantial. And the second is that the strength of the identification evidence following the social media trawl is a question of weight that was properly left before the jury to determine. If I may be of no preliminary assistance, I will continue straight away to my first head of submission.
Thank you, Mr. Johnson.
I will start with what is conceded. It is accepted that there was a breach of Code D when the police failed to take a first description of the suspect at the time of the incident. But what is being submitted is that this breach does not cross the threshold of significant and substantial so as to render the evidence that followed inadmissible.
Can I just stop you there, Mr. Johnson, just while we're investigating this submission? Surely PACE is there for a reason. It's been enacted by Parliament. It was to remedy flagrant breaches of procedure and conduct by the police in the 70s and 80s. It's there plainly for a reason. And is it not that the fact that a breach has occurred here are not grounds in itself that we should exclude this evidence? If there's a breach, isn't that the end of the matter?
Well, respectfully not, my lord. It has become black letter law that a breach in and of itself is not sufficient to render the evidence inadmissible. The breach must cross this threshold test of significant and substantial. And the authority for that case can be found in the case of Quinn, I believe, on page 19 of the bundle.
Thank you.
In making this submission, we ask that the cases of Walsh and Keenan are distinguished. In both Walsh and Keenan, the breaches related to Code C, what are known as the verbaling provisions. These are safeguards against the police inaccurately recording or inventing the words used by a detainee in an interview. If I may turn the court's attention to the case of Keenan, which can be found on page 35 of the bundle.
Thank you.
At the bottom paragraph, at the end of the third line of that bottom paragraph, Mr. Justice Hodgson provides the reasons why particular weight is given to this kind of breach. If the appellant intended not to give evidence if the officer's evidence was excluded, then admitting it unfairly robbed him of his right to remain silent. Just over the page now on page 36.
Thank you.
If the defence was to be that the interview was inaccurately recorded, then it was plainly unfair to admit it because it placed the appellant at a substantial disadvantage in that he'd been given no contemporaneous opportunity to correct any inaccuracies. In Walsh and Keenan, the fact that the defendants were not given the opportunity to verify their words at interview gave rise to a positive obligation on them to give evidence at trial. Drawing both cases together, the breaches were held to cross this threshold test of significant and substantial because they gave rise to procedural unfairness. They did not concern themselves, contrary to my learned friend for the appellant submissions, with a substantive assessment of the evidence itself. The resources are just not available for that in this court.
Mr. Johnson, if we were to have sat on the trial and to have admitted this evidence, wouldn't potentially the same flavour of procedural unfairness have arisen? Because what would have happened then is that this identification evidence would have been put forward as part of the Crown's case, and the appellant may have been A, robbed of the opportunity to make a submission of no case to answer, and B, may have felt very much more under pressure to give evidence to explain what was seemingly fairly damning identification evidence from an independent witness.
Well, I'm grateful, my lord, but I would suggest that there is a distinction between the breaches in Code C in that regard and breaches of Code D, because in that sense, breaches of Code C, which relate to words that a defendant is claiming were never said, requires the defendant himself to take the stand and give evidence to rebut that evidence, whereas a description evidence, as in the case now, can be rebutted with oral submissions without the need to give evidence. There is no evidence or point of view that the appellant could have given at trial that would have rebutted that evidence.
Well, that's, Mr. Johnson, that's not right, is it? Because if the prosecution can't put forward a positive case that he's there, he doesn't have to do anything. But if they can put forward a positive case that he's there, it puts more pressure on him to go into the witness box and say, well, actually, I wasn't there, doesn't it? And indeed, we have no information or evidence in respect of what the defendant's intentions were in respect of giving evidence at the original trial, I think.
Well, my lady, that is the case regardless of the breach. The case against the defendant is that he was there. The obligation to take trial to challenge that evidence and that point of view remained the same, whether or not the description was delayed or not, because in effect, the impact that the breach had was that there was a delay between the interaction and the description. Whereas in the cases of Walsh and Keenan, there was no delay in the sense that it was not remedied in any way. In the present case, although there was a delay, a first description was eventually taken. And this provided the appellant with the means to challenge and test the evidence. Whereas those means were stripped of the defendants in the cases of Walsh and Keenan, therefore giving rise to the procedural unfairness.
Thank you.
On that point, Mr. Johnson, how do we rule out the possibility that Mr. Whitehall has simply identified a person he saw online as opposed to a person who he gave a description apparently 2 months after the event?
Well, this is a really important distinction, so I'm grateful to your lordship for bringing it up, and it does form the content of my second head of submission, and so it makes sense to move on to that now. And in short, the submission is on that point that is a question of weight. It is a question as to the quality of the identification as a result of the delay and as a result of the social media searches. It became a question of fact. Was this witness identifying the suspect or the social media photographs?
Thank you.
So if I may make this point using some case law, can I turn the court's attention to the case of McCulloch, specifically looking at the page of 50 in the bundle?
Thank you.
At paragraph 13 of this case, on the third sentence in of that paragraph, Lord Justice Richards provides the authority that the various specific points made about the weaknesses in the identification process went to weight and were not sufficient to render the identification inadmissible. This was the case that was also affirmed in Phillips and Phillips. In both of those cases, the evidence was held to be admissible, despite the fact that there was a risk, as my lord has brought to attention in this case, that the witness was identifying a person they have seen in the social media photographs and not the person they saw on the interaction.
But in that case, Mr. Johnson, it was followed up by a viper, wasn't it? Which I think is not the case here, which gives some credence to the social media identification that this jury would have been without. What do you say about that?
Well, respectfully, I think that the case was followed by a viper in the present case. There was a viper identification following the first description and following the social media trawl.
Thank you.
In making this submission, there are, however, 2 points of contention which I must address. The first of which is the issue of what the witness said during that viper. And the second is the issue of the lack of supporting information regarding those social media searches. Regarding the issue of what the witness said during the viper, the words "I've seen him on social media" might appear to demonstrate, indeed, that the witness was identifying the social media photographs and not the appellant, or rather not the suspect he saw commit the crime. But I submit 3 reasons why these words should not be relied on in this way as a basis for your lordships and your ladyship's judgment. The first is that in both McCulloch and Phillips, the viper identification took place after the social media photographs had been seen. The chronology of identification in all of those 3 cases remain the same, and therefore the underlying risk remains the same.
Well, that might be the chronology of it, but those were the words the witness said. This is the person I saw from social media. And doesn't that put his evidence in a very unsatisfactory state of affairs? How could that have been properly left to the jury if that is what the witness was saying by the means he identified the alleged perpetrator of this event?
Well, the first point to make in response to that is that those words being spoken doesn't in fact increase the underlying risk of contamination, because the risk of contamination was independent of any words that happened to be spoken or not spoken. But directly addressing that question, the fact that those words were spoken provided the jury with something tangible on which they could base their verdict. It turned the question from one of hypothetical risk into one of fact. They were answering the question, did this witness identify the suspect or the images? Without those spoken words, the question could only ever have been as opposed to a hypothetical chance that this has happened. And so the words turned the issue from one of risk into one of fact. And questions of risk concern admissibility, but questions of fact can be entrusted with the jury.
We have your submissions on the point. Thank you, Mr. Johnson. If you'd like to continue.
Well, the final thing to note in response to that statement individually is that it is actually uncontentious. It's not in dispute that the witness saw the appellant on social media. There is no exclusivity in the words used, and so there is no reason to infer from them that the witness is suggesting that he has not seen the appellant anywhere else. There's been no evidence before the court to suggest that the witness was acting in bad faith. And so it is his honest belief that he has seen the appellant on social media, and he has seen him committing the crime.
But we don't have that evidence, though, do we, Mr. Johnson? All that we have is I provided a description several months later. When I attended the identification parade, I said, that's the man I saw on social media.
2 minutes remaining.
Well, the submission is that those words include no exclusivity. So that is the man he's seen on social media. But the whole purpose of his witness evidence at all and the identification is that he is submitting that that man he has seen on social media is the same man that he has seen commit the crime.
Thank you, Mr. Johnson.
If I may move to my second point of contention, this is the lack of supporting information regarding the social media searches. And I'm mindful of the time, my lords and my lady, and so I will keep this brief. But in both the cases of McCulloch and the cases of Phillips, the lack of a supporting information was not held to be an influential point in rendering the evidence admissible. And indeed, in McCulloch, the entire lack and unwillingness, as in the case before the court, of the witness to provide any information did not affect the admissibility of the evidence. And in the case of Phillips, while the photograph was shown to the jury, there was no information provided as to how many times it had been seen or any contextual information at all. And so if I may be of no further assistance to the court, I respectfully ask your lordships and your ladyship to dismiss this appeal on both grounds.
Thank you, Mr. Johnson. My lord and my lady will now rise and we will consider our judgment and we'll invite the parties back to court in due course when we will deliver a fully reasoned judgment as to how we are disposing of this appeal. Thank you both, gentlemen.
Thank you very much. Great submissions from both of you there. So as I say, we have a Q&A session now. So I'll pass over to each of our judges just to do a quick 30-second introduction about themselves, just in terms of their specific practice area maybe and where they are. So I'll hand over to Jazz Daliwal first, just for a very brief introduction.
Thank you, John. Evening to you all. Hope you're surviving the heat better than I've been today. Firstly, virtual round of applause I'd like to give to Cason and to Matthew. Very good submissions, and hopefully you can all learn a lot from just watching what you've already seen. In terms of myself, I'm a barrister at Citadel Chambers in Birmingham. My primary practice is in respect of criminal law. I've been at Citadel since January 2020. I began my pupillage back in I think November 2018 at KBG Chambers in Plymouth. And yep, so I spend the majority of my time doing criminal work day in, day out. I'm in court, doing advocacy and doing the job that is quite a fun job at times of being a criminal barrister.
Excellent, thank you. I'll hand over now to Beth for a brief introduction.
Thanks, John. And yeah, I'd like to echo what Jazz has already said about both competitors. I thought that was absolutely exceptional mooting from both of you. Yes, so I'm currently a pupil barrister at 9 St John Street Chambers in Manchester. I started my pupillage last September, so I'm about halfway through second sit. So I've been on my feet now for about 3 or 4 months. Before I started pupillage, I did the bar course at BPP in Manchester, finished that last summer. My pupillage is a specialist PI pupillage, but I also do a little bit of crime. So I spend a lot of time currently in the Magistrates Court prosecuting, which is, as Jazz said, sometimes great fun.
Thank you, Beth. And lastly, I'll hand over to Robert for a brief introduction.
Good evening, and I too echo the sentiments of both of my fellow panelists. I thought it was a superb moot, and exceptionally well done to both of you. So my name's Robert. I am a future pupil barrister at Parkland Plowden. I'm going to be starting with them in October the 3rd, and then going through obviously till next year, starting my second six, and looking forward to that in April. My pupillage is a civil pupillage, so employment, clinical negligence, personal injury. And I'm thoroughly looking forward to getting started with it. At the moment, I'm doing some deviling for a member of chambers. So I'm getting some experience and getting used to what it will be like in practice, but no, can't wait for October.
Thank you very much. So those are your panelists for this evening. So I'm going to start off by running through some of the pre-prepared questions that you will have submitted in advance. So we'll do that for about 15 or 20 minutes. If you can think of any questions that you want to put to our panelists, you can either pop them in the chat box and we'll get to those questions later on in the evening. Or if you're feeling brave later on, you can pop your hand up and ask the question personally. So we'll start with a nice open question that was posed from somebody that signed up. And I'll put this to all three of our panelists. So what is the best skill to have as a good advocate? So we'll jump in the same order that we've ran through so far. So Jazz, would you like to start on this one? The best skill to have as a good advocate?
It's a difficult question to answer, because I think, and I hope I'm not sitting too much on the fence here, but I don't think there is one particular skill that that a barrister needs to have. I think that the beauty of advocacy is everyone has their own different style. People have different strengths and weaknesses. Some people can achieve just as good a result in a devastating cross-examination as they can negotiating beforehand and still get an ideal and good result for their clients. So everyone has their own individual style. Everyone has their own individual strengths and weaknesses. And I think advocacy is more about highlighting your particular strengths and your particular skills. But I think if I tried to narrow it down to what I think I try to focus on as much as I can, I think it's very difficult to get past just the ability and need to work very hard for an extended period of time. I think that slightly transcends everything, really. If you put hard work into your preparation, into the way you conduct your advocacy in court, the way you deal with your clients, and put effort into building relationships with solicitors and generally just putting the effort in, I think that is something which I've seen to be a very consistent feature in some of the advocates I look up to and I really admire, just their ability to work very hard for long periods of time for many years, not just for the short term. I think secondly, and it's one that I stole from an advocate on a Q&A session a few years ago, actually. I think the ability to work with people and get on with people and be just generally be quite nice and be a nice person. I think that's quite an important skill. I think it's quite an underrated skill. My job, at least, and especially in criminal law, we're dealing with people every day. Every day I'm talking to a different person. It's a different judge, or it's a different client, or it's a different solicitor, or different court clerk, different usher. And I think if you can get on with people, it makes your day easier, it makes their day easier, it helps you get to, I think, the outcome you're looking for easier. And also perhaps it goes into the hard work element of it. It helps you enjoy your job. If you're having nice, pleasant interactions with people and getting hopefully positive results out of it, it helps you to enjoy the job, helps you keep going for the long term and maintain that passion, I think. So those are two things which I think are quite important in the work we do.
Great advice there, Jazz. And I completely echo what you say there. So thank you. Beth, any thoughts to add to that?
Yeah, I think that hard work and preparation is always going to be the sort of stock answer. And I think that's going to come up in response to quite a few of the certainly prepared questions that we've received. I think another skill, which sometimes is overlooked, I think, when we think about advocacy, is the ability to listen. That's listen to your opponent, to what they're saying. The number of times I've been in court in second six and I've, for example, conceded an issue And yet my opponent has still pursued it as an issue in the closing speech. And the judge has said, did you not listen to what your learned friend has just said? She's conceded that. You don't need to raise that point. So I think being able to listen is going to help you to narrow down the issues and only deal with the things that really need to be dealt with. The other key thing is to really listen to the judge when the judge is asking you a question, because sometimes when you do your preparation, you might identify a sort of problematic area for you in your case, and you think, oh gosh, he's definitely going to ask me about that. And sometimes when the judge does ask you a question, you can think they're asking you about that, and actually they're asking you about something completely different. So listen really closely to the question, ask for clarification if you need it, and answer it in the knowledge that you've fully understood that question and what the judge wants from you. And sometimes the judge is giving you a bit of a direction. He or she is trying to lead you down a path because that's what they want you to deal with. So take your next steps from where the judge is leading you.
Great advice there, Beth. And lastly, Robert, any final points on what makes a good advocate?
Well, I think those are all very apt, but to come up with something slightly different for the sake of variety, I would say versatility, in a word. I think if you want to see the importance of versatility, you only need to go as far as watching some of the Court of Appeal hearings, which are available online. When you watch those hearings, you see sometimes the judge will be prepared to be guided by your submissions. And of course, in a moot, that's usually what happens. They're interested in what you've got to say and how you want to structure it and set it out. But other times, and particularly when you see the Court of Appeal, the judges will have read the papers. They'll come to the hearing with a specific predetermined view of the issues, what those issues are and how they want to get about resolving them. And they'll have specific questions or concerns that they want to raise in line with that view. And another thing I think on versatility, which is you see this a lot in mooting, I certainly have, counsel being asked a question and saying, well, I'm going to come to that. So if you could just bear with me, give me 5 minutes, and that's part of my, my second submission or my third submission. And I thought tonight watching the moot, Matthew did that very well, because he was asked a question and put in that position. And he said, well, that is part of my second submission, but as it's been raised now, we'll move straight on to it. If you don't answer the question that the judge has at that moment, all they're going to be thinking about until you do answer it is that question. So you're basically wasting air and time and energy by not moving on to that point. So versatility, being prepared to obviously have the course that you want to set out in your submissions, but being prepared to realize that the court isn't with you on that and wants to perhaps hear them in a different way, hear them in a different order. That is fundamental to being a prepared advocate and turning up for court.
Great advice from all of our panelists there. Now, of course, turning to mooting, the next question relates to moots. The question is there a danger of being too formal or formulaic when mooting? So the example given, it says, for example, ending each point by informing the judge when you've finished with that point and that you'll move on to your next point. So we can expand this a little bit beyond that, so sort of any sort of general tips for mooting, but if we can start with the point itself, about sort of the how formulaic you need to be when it comes to mooting. So do we have anyone that wants to jump in with a suggestion on this?
I don't mind just giving a couple of thoughts. I think it's difficult to be too, well, I mean, obviously you don't want to be too formulaic and come across robotic, I think is maybe the point. But I don't think there's anything wrong with signposting or obviously informing the court of that you're moving on to the next point. I think that's the right and proper way to do it. And those kind of formalities, at least in a moot, you might not necessarily do them in court. I wouldn't necessarily do that if I was doing, say, an application to exclude a certain piece of evidence at every step of the way. Probably be a bit more natural. But when it comes to a moot, of course, there is a certain marking criteria. And of course, being able to comply with the formalities and understand the formalities of the court, I think is always a good thing. I think it shows that you're really paying attention to the details, the little details, that you're not just thinking about the big picture submissions, but you're also going slightly further and picking up on how you can make it as easy as possible for the judge to follow you, and also as accessible for the judge to hear your submissions. I take the phrasing of that question, formulaic, to mean, of course, you don't want your advocacy to become, as I said, robotic. You don't want it to become, you don't want the formality to get in the way of what you're actually trying to say. So if you're wasting lots and lots of time dealing with citations and page references, try and cut back as much as you can, as much as you reasonably can, and focus on the actual submissions. But it's a balancing act, of course, because at the end of the day, as much as advocacy is subjective, I think judging is as well. And some judges will tend to gravitate more towards formality than others. And that's just a natural part of it. Everyone has their own individual preferences. And I think you've just got to be aware of how much you can comply with the formalities to show that you've got that mooting ability, whilst at the same time being able to actually get to your point and actually make your submission.
Thanks, Jazz. And
I think that's it. Sorry, John. I think that's it. It depends on the tribunal. You know, some tribunals will want you to be more formal than others. And you know, sometimes you just want to get straight to the point. But I think with mooting, you do have to accept that there is a degree of formality that's perhaps expected over and above general advocacy in practice. And that is part of it, as Jazz says, that's the marking criteria. You've got to tick those boxes to get the points, as it were. But I think it's also worth noting that you will make mistakes with that formal approach along the way, but that's not necessarily a bad thing, I would say. I mean, you can develop and practice those formal techniques, and they don't really come naturally to any of us. I mean, no one starts most of the things they say with "may it please" whoever you're talking to. But once you get to grips with that, and you start getting comfortable with the language and getting comfortable with the structures, then you can start to rein it back. So I think don't be afraid to make mistakes early. I certainly did, and I've been told many times, you know, that was too formal or that lacked formality, and you have to experiment and find your own way. But I think it's part of the process of developing those mooting skills is to make those mistakes. And if anything, it's probably best to be slightly overly formal. But as soon as, for example, the court says, well, you don't need to bother with citations, take that on board. Don't keep hammering the same point. Once you get the idea that they're not with you on something in your style, change it very quickly. And again, that goes back to the versatility thing.
Thanks, Robert. Beth, any final thoughts?
Yeah, I completely agree with what's been said already. I think with formality, there's always a danger of swinging too far either way, either being far too formal or not formal enough to the point where the tribunal actually find you coming across as rude as an advocate, which it would always be preferable to be too formal than to go too far the other way. I think in terms of the signposting in particular, it really depends on how complex your points are and how complex your structure is. If you're only making 3 main submissions, it's probably not necessary to be as formulaic as if you've got 4 submissions within 3 grounds, for example. Signposting is all about helping the judge to follow where you are. And I think it's very context-based. I don't think there can be a hard and fast rule on that.
Yeah, completely agree. I'd agree with all of the advice there. And I think the thing to remember is that with mooting or any form of advocacy, it's about trying to be persuasive. So, you know, if you're worried when it comes to being formulaic about point 1 is, point 2 is, I think you're going to bore the judge quite quickly. What you really want to do is, you know, use the skeleton argument to your advantage. So if there's a particular point in the skeleton argument that's going to support your argument, then bring the judge back to it, refer the judge back to the skeleton arguments at that stage. But don't worry too much about saying, I'm now moving on to point 3. Let me begin this. So, you know, it needs to be almost conversational, but maintaining the formality that's required for mooting.
I was just about to say there, John, I totally agree. You're there to have a conversation with the judge, not to give a speech. Yeah. And I think once you get to grips with that, and that, you know, that certainly took me some time, because you prepare your submissions and you just want to deliver them. And if anything, when the court asks you a question, you think, especially in the time pressure of mooting, you think, oh, for goodness sake, I just want to get to the end of my speech, and you're wasting my time in asking these questions. It's completely the wrong way of looking at it. When they ask you a question, it's because they want to know the answer, and it's a helpful way of developing your arguments from that point of view. But you're there to have a conversation, not to give a speech.
Completely agree. Great advice there. The next question relates to trial advocacy. So this might be one for Jazz, and possibly Beth might have some answers on this as well. Any tips for effective cross-examination? I'll start with Jazz as the most experienced panelist.
Well, not massively experienced, but still learning. So every day is a school day. I think that the first thing when I think about cross-examining any witness, the first thing I think about is, what do I want to get out of this witness? What is my objective here? What is my case theory? And I think I always think quite carefully about what is my client's case and what is my case theory. Or if I'm prosecuting, of course, what is a prosecution case and what is our case theory? And how exactly does this witness fit into or not fit into that case theory? And I think quite quickly I narrow down the key topics and the key areas that I need to address with the witness that support my case theory and go against the other side's case theory. After that, after I initially kind of brainstorm those few points, you have to think quite carefully before you get down to really putting the questions together is again, like Robert said previously, your audience and your tribunal effectively. Witnesses come in all different shapes and sizes, different ages. So you can have youths as witnesses, children, vulnerable people with difficulties and disabilities, elderly people, people just middle-aged or young adults. You get the whole different range of spectrum. And so before you get on with really getting into your questions, you have to know, how is this person going to respond to those questions, and are my questions appropriate for that witness, and am I going about it the right way? And then I think I get down to thinking about the questions, but I generally try to keep it a bit more loose now, and I think it's something that you get better at as you get more experience. When I first started, it was all quite formulaic. The questions were already in my head. I had a good grasp exactly the phrasing of the question I was going to use. But I think as you get more experience, you just focus more on the topics effectively, like I talked about previously, and exactly what the end result of that topic should be. So at the end of me addressing this topic with this witness, I hope to get this answer out of it that I can later rely on if I cross-examine a different witness or in my closing speech. So I think you want to try to keep it as flexible as possible in that regard. And again, that slightly goes back to, I think, what Beth said at the start, when you should be listening to the witness. And that was also something which I've worked a great deal on over the last few years, is actually listening to what the witness is saying, as opposed to presuming you're going to get that answer because you've assumed it will go the way it goes. Sometimes you ask one question, you get exactly the answer you need, and you can just move straight on to the next topic. You don't have to bother with the other 10, 15 questions that you had prepared. So always be listening to the witness and staying alive to exactly what's being said. And then you can adapt your cross-examination as you go. I think that's important, is think of it as an adaptive process. It's a living, breathing thing, effectively, if you want to think of it that way. It's not a rigid structure and formula that you must have prepared well in advance of the cross-examination. Try to keep it as flexible and as workable as you can.
Great advice there, Jazz. That was quite a comprehensive answer there, so you've covered quite a lot. I don't know whether our other panelists have anything to add to that.
I did have one other point, which is that I think the tendency with cross-examination is to think, right, I need to challenge this witness. I'm challenging their account because I don't believe them and what they say doesn't help me. But actually, confrontational or challenge a witness, sometimes the witness that you're cross-examining can help you. They can give you an answer that you want. And Jazz touched on this in his response. Last week, I sat in on a murder trial, and there were 2 defendants, and it was really interesting to watch how the barristers moved between, at times, being challenging towards a witness, so saying, no, that's not right, this has actually happened, but at other times saying, yeah, that did happen, didn't it? My guy wasn't the one with the hammer, for example. And it's, again, thinking about what you want to get out of the witness, whether being cross with them in cross-examination is the way to do that, or actually can they just help you, because on that issue you've got the same goal as the witness.
Definitely great advice there. I think one other point to make it is, think about where you're going with that witness. Build up in stages, nice short questions, and building up to your point are normally the best way. There's often a temptation to try and throw everything in at once and raise about 5 points in one question with the witness, when it doesn't really help anyone. So keep the question short and simple, 1 point at a time, 1 point per question, and know when to stop. It can often happen where you ask one question too many, you get the wrong answer, and it blows your whole case to smithereens. So once you've got what you need, stop, get out. Right, next question, probably once again will be for the same two panelists again, so Beth and Jazz. Any tips for starting out as a criminal pupil? So obviously, Beth, you've covered a little bit of crime, and Jazz, you've covered crime within your pupillage. So any tips for starting out as a criminal pupil?
Yeah, I started as a PI pupil, and it was only as I got further in that I had a discussion with my pupil supervisor, and he thought it would be useful for me to do some crime, primarily actually because my bar course was fully remote, and so crime was a really good way to see in-person advocacy. I think one thing you can do before you start is just go back to the basics, go back to your criminal procedure, make sure you've got those basics under your belt so that if you have to make a bad character application, you don't have to spend 30 minutes reviewing your notes. You've just got those in your mind. As a first six pupil, what I started to do when I was shadowing was prepare a case as if I was actually doing the case as the barrister instructed. It's good to go and sit in and watch, but it's even better if you thought in advance about how you would do it, because then you can compare how you prepared it to how somebody else has done it, and it will never be the same because we all have different ways of doing advocacy. But you can see the successes of how that barrister has done it and perhaps think, oh, actually, I think the way I prepared it might have had a better result in this case. So rather than being a mere observer, I would say try and participate in it as much as you can.
Excellent, great answer there. Jazz, anything to add?
I agree with everything that Beth has said there, absolutely spot on. I think the main thing I would say is just watch everything you possibly can. Observe, pay attention to every single detail as much as you can. It's not always easy. I think when you're a pupil, there's a tendency to feel, and I certainly felt, just quite self-conscious. You want to make sure that you're not saying anything you shouldn't be saying, or coming across a way that you don't want to come across, and you spend a lot of time worrying about how you're being perceived. But just try to pay attention to your supervisors as much as possible, the other advocates, how they interact with each other, how they negotiate, how they deal with court staff, all those sorts of little details. I think are, aside from just the nitty-gritty of the law, I think those are really important aspects of learning how to be a successful pupil, hopefully. And I think just flowing on from that would probably be asking questions. Ask questions. It's not always easy because advocates are busy and running around courts, and there's lots to get done. But if you can find a quiet moment just to ask a burning question or anything like that, it shows that you've really paid attention to what's happening during the day. I think the final thing I would say, and what helped me a lot during my pupillage, is to try to develop a network or a network of people that you trust and that you can turn to at a moment's notice. If you have a difficult case the next day, you need to run through ideas with someone, or just generally discuss how things are at the bar, whether it's someone close to your level of call, a few years senior or very senior. It helps to have a few people, just a few contacts that you can ring up and who can guide you through those early few months.
Good tips there. Thank you, Jazz. Right, I think I'll turn to one more question before we open this up to the audience. This is open to anyone, and this can apply to either mooting or sort of court advocacy. Which aspect of advocacy do you find most difficult, and how have you looked to overcome that difficulty?
I think it's, just as I was alluding to earlier, it's about getting to grips with the purpose of why you're there. You're there to persuade the judge. How do you do that? You have a conversation with them. You're not there to give a speech. That's just not going to work. It's not going to be interactive. It's not going to be the best way of actually getting through the issues. It just doesn't work like that. So I think always coming back to that motto of how can I help the judge? Remember, it's that conversation, and it's a formal conversation, which seems like a bit of a dichotomy at first, but once you get to grips with those basic structures and basic modes of language, which we were talking about earlier, then it becomes a lot more natural to do that. But I think that's what you've got to keep returning to, is thinking about how can you assist the court. And of course, a large part of that is in preparation as well. If you know where your page numbers are, you know what your cases are, you know your points, then the conversation again becomes a lot easier. So I think doing all of that preparation makes it so much easier to be natural when you're then appearing in front of the tribunal, because you've got all of that work and that confidence behind you. You can then start to relax into it, and you can actually see it for what it is, which it should be a two-way dialogue. And if it's not a two-way dialogue, the judge isn't engaging with what you're saying, then either it's going very, very well or very, very badly. But probably most of the time the latter rather than the former.
Thanks, Robert. Does anyone else have any advice on this point?
I think Robert covered a great deal of it there. I think it's a very good point. When you're first on your feet and you're first doing your first bits of advocacy, it's very easy to feel very awkward. It's very easy to, I think, as Robert said, just have everything. Effectively, you just want to give your speech and get out of there, rather than have the conversation. I think that's something that just comes with experience, really. If you just keep doing it, and that includes mooting, doesn't necessarily have to be the job, mooting, debating, these types of events and activities, help you develop that more natural flow, that more natural style, which fits into your way of doing it. And then it becomes more of a conversation. You're less reliant on even just things like notes, effectively, and you can just you have your case in your head, and you can just focus on having that engagement with the judge or with whoever the tribunal is, whether it's a jury or whoever it might be. Thank you.
Beth, any final thoughts on that point?
I think it's mostly been covered. Maybe to deal with it from a slightly different angle. I think when you start out as a second six pupil in particular, you need to expect to face some challenges and also some criticism. And it's something that we see a little bit in moots, but it's quite a supportive environment when you're mooting. When you're in court for real and you have real judges who have a lot of cases to get through, some of them can be a little bit impatient with you, and some of them can be really quite critical. And I think it's important to recognise that that's normal when you start out. At least that's what I've been told. And that you just have to do your best and crack on and not crumble under that pressure. Keep your head, keep going, and you'll learn for the next time. But that idea that criticism is bad, I think, is something that comes through academics. And I think putting that to one side and just thinking, no, I just need to get through this, keep my head, make the points I need to make, even if I've not got the best case, for example. I think that's a really important thing to recognise as a pupil.
Yeah, so Rebecca and Michael, do you have anything to add on this point?
Yes, I mean, I think the original question was about whether what we found difficult and how we overcame it. And from my point of view, it was knowing how far's too far, which is something I tend to struggle with in real life. I like the courtroom because it has rules and it has structure to it that a normal social interaction doesn't. But sometimes I would be concerned, or well, is this point going to sound a bit stupid, or is the judge going to think I'm an idiot? Am I going to get told off for raising it? And the reality is, if it is well-founded, arguable, properly arguable, is what you need to always come back to, because that's the ethical principle, and you can support it in law and in fact, then you are welcome to put the point, even if the judge is going to disagree with you. So just think about the best way of putting it. And that's what I found the easiest way of dealing with that nervousness, which comes from being new and comes from not necessarily knowing the tribunal that's in front of you. But any good judge will appreciate any well-put point, even if they ultimately disagree with you.
One of the questions that came up before, and I'll turn this question to Michael and Rebecca, who haven't had a chance to answer this. What would you say the best skill is to have as a good advocate? or what skills can we look for in a good advocate? It's not one single skill. What skills would a good advocate have?
I think two things that are generally helpful. Obviously, there are specific skills, but trying to think of it in terms of the generality. I think one is robustness, because you need to be able to deal with the difficult judge and even things like the difficult witness, because it can be quite trying at times to cross-examine a witness who's a bit rude, because of course the judge is the same as us in the sense that they're bound by professional conduct rules, and therefore even if they find me incredibly annoying, they will generally keep that under their hat. Whereas witnesses who I'm putting under pressure don't have that same obligation. And you can sometimes find that they become quite rude, quite aggressive, and you have to remain robust enough to keep pressing points in the face of sometimes a degree of criticism, and to be able to sort of take control of the situation as the lawyer rather than as the witness. So I think robustness is very important, because it really underpins your ability to put your case. If you crumble too early in the face of an angry judge or just a rude witness and you just think, you know what, I think I'll just stop there, then it doesn't really matter how good you are and everything else, because you won't have got there in the course of your cross-examination or the course of your closing speech. The second overarching skill that I think is important is having a degree of calm. And that doesn't mean that you don't panic, but it does mean that you try and mask your panic as best as you possibly can, so that when you are in court, you conduct yourself as best as you possibly can, with all of the fuss of a Rolls Royce coasting slowly down a hill. If you start to look as though you're losing control of the case, then you will inevitably lose your judge, who will find you less persuasive. You might lose your client, who will just think, who is this person and what are they playing at? So when things start to go off what you might have expected, so for example, you are cross-examining a witness and they say something that you simply were not anticipating, the ability to calmly and coolly deal with that and keep a clear head, I think is very important, because then again, it allows all of your other skills to come to the fore. Whereas if you panic, then sometimes your polished skills simply don't get the chance to shine because you're too busy panicking and maybe saying something silly or doing something that you shouldn't. So I think those two things are important: robustness and calm, or the projection of calm.
Great practical tips there, Michael. Rebecca, anything to add?
Yes, they somewhat overlap, but I would say the ability to fake it till you make it. We're in a profession where imposter syndrome is rife. I struggle with it. It affects my drafting more than my advocacy, because if I say something a bit silly, everyone accepts that you're on your feet. Whereas if you send something that you're supposed to have read, reread, proofread, done all the research on, and you say something a bit silly, it's a lot more embarrassing, and potentially other consequences. And I always give the example of the duck. It's often the swan, but I think as new lawyers, we should settle for being a duck, and being completely calm on the surface, even if our legs are panically moving underneath the water. And the other is the ability to take time and to pause. It's often very intimidating to ask for a moment, but where you have judicial intervention, it's often better to say, can I just take a moment to consider that question, than it is to start rambling and hope you're going to get to the point eventually. Judges much rather you take 10 seconds to think about it than come out with some nonsense. And hand in hand with that, and something I think that was asked earlier that I came in partway through in respect of witnesses, is silence. Don't be afraid of the silence, because sometimes in cross-examination, silence is golden. You ask a question and they can't answer it, you give them every fair opportunity to answer it. And I tend to do it in stages: ask the question, ask if they need the question again, reword the question, and then I will warn them of the inference that I'm going to ask the judge, because I do civil, so I don't have the jury. Warn them of the inference I will be asking the judge ultimately to make from their silence, but it is hugely impactful. And if you're just hurrying them along or moving on to the next question, then that doesn't hang in the air in quite the same way.
Great advice. Right, the next question that we have is, do you notice any common mistakes in closing speeches? So I'll open this one up a little bit. So we won't just look at mistakes, we'll look at any general tips for closing speeches as well. So I will open this to all 5 of our panelists. So are there any mistakes that you see in closing speeches or any tips for closing speeches?
I think there are a couple of things that spring to my mind. One is a lack of structure. So you'll sometimes, and I'm as guilty of this as anyone that I've seen, you'll sometimes hear a closing speech or give a closing speech, which is something of a blunderbuss of points. And you are saying everything right, but you almost want to get the transcript and chop it up into sections and put it into a much better structure, because if you do that, then your points will be that much more impactful. But I think particularly in civil work, it tends to be the case that as soon as you finish the evidence, you go straight into giving your closing speech. And so you don't necessarily have time to reflect on what you'd like to say. So you have to have something of a structure beforehand that you've identified as being the right way of doing it. And then you have to supplement that with obviously the evidence as it has in fact come out. But what I sometimes see is people that just sort of pick points seemingly at random and make all the points, but don't necessarily put them all in the right order. And then the other thing that I think isn't necessarily, well, the other thing that I see in closing speeches a lot is either pushing the wrong point or not dealing with adverse points at all. So sometimes you will have instructions and you'll have to put a point that's bad, but you should know if you're putting a point that's not your strongest point. And I have seen a lot of advocates really push things where the law is just against them or the evidence is against them. And that tends to alienate the judge and mean that when you do get onto your good point, the judge is already rather lost on what it is that you're saying, and you've lost a bit of credibility there. Conversely, of course, you can't just ignore bad points. You have to try and deal with them as best as you can and not just leave them so that the only party to have referred to them is the other side, because that would be much more damaging. So that's a few tips.
Thanks, Michael. Some good tips there. Do we have any thoughts from any other panelists?
Very quickly, a point which comes to mind for me is that the best closing speech I've ever seen, best closing speech, jury speech I've ever seen, it's quite a few years ago now. And I remember it was a multi-handed drugs case. I think it was about 2 weeks long. And out of all of the, I think, 6 or 7 defendants, that closing speech was the shortest. I think it was only 20, 25 minutes long, if that. All of the other speeches were at least double, maybe 3 times longer than that. And the barrister who made that closing speech, his client was the only one acquitted. That doesn't necessarily mean that was the world's greatest closing speech and that was the only reason why his client was acquitted. But the length of your closing speech doesn't necessarily correlate with the quality of the closing speech. Concision, directness, and also not patronising the jury, I think are always good things to bear in mind when it comes to closing speeches.
Excellent. Good practical tip there, Jazz. Okay, I think what
Sorry, John, I've just got one more very boring.
Oh, absolutely, yeah.
I've never done a closing speech. I've only seen them. So my point is purely a practical one, but I do think it's important to remember as you go through the trial, you're hearing the evidence, and as has been said, as Michael alluded to, often in a civil trial, you're just going straight into the closing speech. So you've got to take a good note of all of that evidence so that you can then refer to it and have an organized system so that you can know which evidence from which witnesses you want to point to, and that's easily at your fingertips. In assisting with a closing speech preparation, that's what I've seen. The clearer your note is, the easier it then becomes, especially in the moment when you haven't got the benefit of time to get a good closing speech structure together because you've got it all at your fingertips.
Okay, so ladies and gentlemen, I will now hand over to our presiding judge for judgment.
Thank you. This is an appeal brought by Mr. Sam Andrews against his conviction before a judge and jury in respect of one offence of criminal damage. The appellant today was represented by Mr. Yong of counsel, and the Crown was represented by Mr. Johnson of counsel. The court is grateful for the able written and oral submissions that were made before the court this afternoon. It is the Crown's case that on the 3rd of June 2021, the appellant, along with two others individuals, intentionally damaged a sculpture at the National Gallery in London. This appears to have been part of a nationwide campaign to damage artwork honouring those who were involved in the slave trade. Two individuals were apprehended at the scene, and it is the Crown's case that the third individual was this appellant. The Crown's case rests solely on the evidence of a Mr. Whitehall, a security guard who was on duty at the gallery at the time of the alleged offence. Sometime later, on the 25th of July 2021, Mr. Whitehall contacted the police to say that he'd seen the appellant on social media and that he could now identify him as the third man. Following this, the appellant was arrested, and at a Viper or identification procedure, Mr. Whitehall identified the appellant as the individual who was involved with the words, and I quote, "Yes, I've seen him on social media," unquote. At the trial, the sole issue before the court was one of identification. Following a voir dire or a trial within a trial, it was established that Mr. Whitehall had searched various social media outlets, but was unable to provide any details of the specific sites or sources that he had searched. Similarly, he was unable to say how many images he had watched, and neither was he willing or able to provide details of the post that he had watched during that internet trawl. Mr. Whitehall also accepted that he hadn't provided a contemporaneous description to the police at the scene. The learned trial judge allowed that evidence to go before the jury, and they duly convicted the appellant. And it was submitted on appeal that the breach of Code D of the Police and Criminal Evidence Act 1984 was significant and substantial, and that the learned trial judge should not have left the evidence to the jury. Secondly, it was submitted on behalf of the appellant that the contamination of the identification evidence by social media was relevant and significant here, and bearing in mind that it was submitted significant contamination, such evidence should have been excluded under Section 78 of the Police and Criminal Evidence Act 1984. In response, the Crown sought to argue that these were matters of weight rather than admissibility, and that with the proper direction given to the jury by the learned trial judge, the conviction was safe. Having heard those competing submissions, my Lord and Ladyship are of the view that the evidence should not have been admitted, and therefore the appeal is allowed. Our reasons are threefold. Firstly, there was, in the court's view, a significant breach of the codes of practice. The codes are there for a reason, and therefore there being a significant breach of that, that makes the evidence unsafe and therefore should not have been admitted before the jury. Secondly, there was very significant contamination here. Mr. Whitehall was given plenty of opportunities to explain what sites or sources that he had searched or visited. There was no context in which his identification evidence from the social media search that would have allowed the jury to have safely decided whether this was either identification by social media or identification from what was seen at the scene of this alleged offence. That being so, there was significant contamination, and again leads us to the conclusion that the learned trial judge should not have admitted the evidence on that ground also. That then finally dovetails with our final point, namely what was said by Mr. Whitehall at the Viper or identification procedure. And I quote again, "That's him, I saw him on social media." Notwithstanding Mr. Johnson's significant efforts to seek to distinguish this and to make submissions that this did not render that evidence unsafe and unsatisfactory, in the court's view, that single sentence in effect put a hole below the waterline of the Crown's case. The witness was plainly, in our judgment, saying, "That's him," only from what was seen on social media. There was no back reference to the scene at the National Gallery on the 3rd of June 2021. And therefore, again, for that third reason, which altogether are interconnected and interlocked in any event, therefore means that this evidence was so unsafe and unsatisfactory, it should not have been admitted before the jury. And therefore, that means that this appeal is allowed on the basis that the evidence in itself was so unsatisfactory, it should never have been left to the jury. The appeal is therefore allowed. That deals with the issues of the law. Of course, the competition tonight is to judge the mooting abilities of the two contestants. And I should emphasize that Rebecca and Mike took a considerable period of time to determine who was the ultimate winner of the mooting competition tonight. To assist us, we had the marking criteria, which we applied rigorously here. It was an extremely close competition, but just on balance, by stepping back and looking at the overall presentation, we award the moot to Mr. Yong, and therefore Mr. Yong is the heat and indeed the final winner of this year's speed mooting competition. And at this stage, on behalf of myself, my fellow judges, and no doubt all the other participants, I'd like to extend a round of applause to Mr. Yong.
Thank you so much.
Mr. Johnson, you should be of the view that you more than ably acquitted yourself this evening. It was a very, very close competition, and it was by applying the strict marking criteria that we ultimately awarded it to Mr. Yong. Mr. Johnson, you should not feel any shame or disillusionment in your submissions. Both were extremely carefully and skillfully put this evening. But thank you both very much indeed.
Thank you very much for the judgment there, Matt. Congratulations to both mooters for making it this far. Well done, Mr. Yong, for winning. And also, Matthew, Mr. Johnson, you should be very proud of yourself for making it this far. I'd like to say a huge thank you to our three judges for taking the time to adjudicate tonight. I would also like to say a huge thank you to our three Q&A panelists as well for giving some great answers for the students. So that brings the National Speed Mooting competition to a close for 2022. This was our 10th annual competition, so we've had 10 years worth of the speed moot now. So I'm very proud of how far it's come. Cason, Yong, your name will be on this trophy along with our sort of 9 other winners from the previous years. And here's to another 10 years of the National Speed Mooting competition. So once again, thank you to everybody that's been involved. Thank you to our judges, not just tonight, but across all of the rounds. Thank you to our Q&A panelists. And of course, thank you to our sponsors for 2022, BPP. So that brings this competition to a close. Keep an eye on the website for future competitions, and I hope to see you all again in the future, both competitors and judges.